the NRA Civil Defense Fund, and Dave Hardy and Adam Winkler and Ilya Shapiro for hosting me here. What's important to remember about this case is not about the Second Amendment. This case is not about fears of the British disarming the colonists. This case is not about James Madison, Thomas Jefferson, George Mason, Sam Adams, and Thomas Paine. This case is not about 1791. This case is about the 14th Amendment. This case is about 1868. This case is about the fear of states denying freed slaves the right to bear arms to protect themselves from the Klan. This case is about the Reconstruction Congress. This case is about 1868. But on an even deeper level, this case is not really about guns. This case is about liberty. The liberty is protected by the Privileges or Immunities Clause of the 14th Amendment. And among these privileges and immunities is the right to keep and bear arms for the defense of person and property. And this is a key understanding from McDonald v. Chicago. What Supreme Court should protect is not the Second Amendment, as was understood in 1791, but the Privileges or Immunities Clause, embodying the right to bear arms as understood in 1868. And this brings us to the question that I think you're all getting. What is this Privileges or Immunities Clause? How does it incorporate rights? And as Ilya and I argue in our article, whatever it's titled, Dave Hardy, Keeping Pandora's Box Sealed.
We just referred to it as Pandora.
Yeah, James Cameron probably ripped that off from the Avatar movie. Adam mentioned Professor Amar's conception of privileged immunities. And specifically, Professor Amar thinks that the Privileged Immunities Clause embody both more and less of those rights enumerated in the Bill of Rights. For example, the 9th and 10th Amendment are federalism provisions. They resist incorporation. So those are out. In my mind, the Establishment Clause is a federalism provision, so that would kind of be out. There's some provisions that are more individual rights, and those that are embodied in the Privileged Immunities Clause.
You may want to embellish on the establishment statement, because not everybody here understands that.
Yeah, that's something I didn't want to go into.
You can do it very quickly. Just that there were state churches at the time of 1789,
right,
up until 1820, 30. Okay. So
Gene Hoffman just did it, but
I saw a lot of the non-lawyers go.
The Establishment Clause was basically meant to prevent the federal government from infringing upon the state's ability to have state-established churches. States had established churches well into the early 19th century, so that was a no-no. But even more so, I think according to Amar's conception, is the individual rights which should be extended to the states are those that are held by individuals: the right of free expression, the right of freedom of association, the right of freedom of speech, the right to keep and bear arms. Not rights that infringe on the government, for example, establishing a church. That'd be a federalism right or a state-managed right. So that's the distinction. Thank you, Gene, for bringing that up. So in our article, we kind of argue that the term incorporation is kind of a misnomer. It's kind of anachronistic. The term incorporation was really devised in the 20th century, where the Supreme Court just started saying, okay, we take these rights in the Bill of Rights and we start them to the states almost mechanistically. We argue that's kind of wrong. What really should be extended to the states, the Due Process Clause, is how this right was understood in 1868. What would the people, what would John Bingham and Senator Howard and the congressmen in the 39th Congress have thought of these rights? And one of the analogies we use in our article...
Because we talk about the framers generally, we revere them, and some people talk about their intent, although originalists don't really talk about original intent anymore. It's original public meaning that most originalists like now. But the relevant framers for our discussion, as Josh led off, isn't Madison, Jefferson, and those guys. It's these names that you've never heard of, but that are now very important in this context: Bingham and Howard and others.
And exactly what I was saying, this is kind of akin to, if you think of it conceptually, think of the Second Amendment as like a VHS video cassette, and think of the 14th Amendment as like a DVD player. Trying to shove the Second Amendment into a DVD player just doesn't work. They're very similar, and they accomplish similar ends, but they're conceptually different. And that's going forward what the Supreme Court should do. And although this might seem simple, many of the amicus briefs filed in McDonald keep talking about Madison and Jefferson and the Second Amendment in 1791. That's just the wrong historical inquiry. It's what we refer to as originalism at the right time. Consider the right at the correct time. And this is a faux pas that Justice Scalia made in Crawford v. Washington and Melendez-Diaz, where he considered the Sixth Amendment as applied to the states. But he only considered evidence from 1791. And so Sir Walter Raleigh, he never considered how it was understood during Reconstruction. And this is a mistake that conservatives make all the time.
Crawford is an interesting case, and there's a series of cases involving the confrontation clause, meaning the right to confront your accuser in court. That even if a child is testifying, you can't do it in some back room by videotape where the defendant can never, literally confront the accuser. And there's a weird coalition with Scalia joining the liberals, or some of the liberals. I think in the last vote, it was dissenting was Kennedy, joined by Roberts, Alito, and Breyer, and the others were in the majority. And now that could flip because Sotomayor looks at these things probably differently than Souter. Anyway, that's a little inside baseball. But Scalia's very originalist take on this, and why he joins with Ginsburg on this, is because he's doing originalism at the wrong time.
Okay, and just like Ilya was saying, and actually, as Adam alluded to before, the test we actually propose is really nothing new. In the mid-1990s was a famous case, Washington v. Glucksberg, where the Supreme Court considered whether a person has an unenumerated right to physician-assisted suicide. This was in the aftermath of the Jack Kevorkian big kerfuffle. And this Glucksberg test is very interesting because the Supreme Court has been using it now for over a decade to recognize rights that are both enumerated in the Bill of Rights, as well as rights that are outside the Bill of Rights. As Adam mentioned before, privileged immunities wasn't limited to just the rights in the Bill of Rights. There are more than that. There are unenumerated rights, rights to perhaps contract, property, things of that nature. So we actually propose that the Supreme Court just extend the existing Glucksberg test. And for the one major reason, it's meant to protect both enumerated and unenumerated rights. And what's interesting then is, I led off by saying this case is not about the Second Amendment. As far as Ilya and I are concerned, the court can resolve its entire case without citing the Second Amendment, well-regulated militia being necessary to secure the free state, direct people should keep bearer shall be infringed. They don't need to cite that. What they need to cite is how this right was understood in 1791. It's this pre-existing liberty that's being protected. And in many senses, it's an even stronger case than the case of Heller, because it was very clear, as I mentioned, that they wanted these free black slaves able to keep the arms to defend themselves against the marauding Klan in the Jim Crow South. Now, there's certain benefits to the Glucksberg framework.
In 1868.
I'm sorry, yes. Thank you, Lynn. Now, there's certain...
It's very easy to do originalism at the wrong time.
I slip into it all the time. Now, there's certain benefits to the Glucksberg framework, and this is probably where Adam disagrees the most with Ilya and I. The Glucksberg test has two factors. One, a right has to be deeply rooted in our nation's histories and traditions. And two, the right has to be carefully described. What does that mean? Well, in the case of Glucksberg, I think it was Rehnquist? I think it was Rehnquist. Rehnquist looked back at the history of physician-assisted suicide and said, well, there is no right going back in the centuries to common law of a right of a person to have assisted suicide. This is just it's not historically rooted in our nation's traditions. So because it wasn't based on history, that right was out. We contend that the right to keep bear arms, as I'm sure everyone in this room will attest to, is deeply rooted in our nation's histories and traditions. From the Revolution to the time of Reconstruction, to even before we had a country, to the British, and they were being disarmed by the colonies were being disarmed by the British. This was something that was very important to us throughout all of our history. So what this test does is really a historical test. And this is the point where we disagree, but Ilya and I contend that the corpus of rights protected by privileged immunities was kind of frozen. Think of it as amber almost in 1868. How was liberty understood at the time of Reconstruction? How would it have been understood by John Bingham and Howard and the newspapers that Dave Hardy dug up in 1868? How would people back then have understood it? By happening this corpus of rights to this originalism at the right time, you really prevent the opening up of a veritable Pandora's box, which is the namesake of our paper. If we no longer limit it to the rights understood back then, you basically open the floodgates to all these positive rights that many scholars seek to imbue into the Privileged Immunities Clause. Ilya will go into a little bit more details of what those rights are, but I think Justice Rehnquist was correct, saying using historical traditions provides the, quote, guidepost for reasonable decision-making. By capping your discretion to history, you really enable the court to stay within the bounds of where the court should be. So, for example, rather than asking what Jack Balkin and Bruce Ackerman think of the Privileged Immunities Clause, we should ask what John Bingham and Senator Howard thought of the Privileged Immunities Clause. I think this will be a very important way of preventing this can of worms from just spewing forth and going to Alice's fears, perhaps unleashing this onslaught of other rights that the Supreme Court just hasn't considered before. But
Alice is afraid of everything.
Alice is afraid of everything, but she's so wonderful. And I think, if you want to jump in now and talk about Glucksberg.
So